And before we continue, I'll just share a couple of thoughts, and then we'll introduce our guests and panelists or um, um, facilitators to take us through tonight's event. And yeah, but says, let us take it with all absolute seriousness as we do for every event and meeting that we take, because I believe it's going to be of a great blessing to us from where I believe we're coming from. When you read through the scriptures in Jeremiah 29, when the Bible talks about God says, I know the plans I have for you, the plan that of good, not of evil, yet to take you to an expected end. When you want to reflect on that scripture, now we are a lay person, if you're not careful, it means that you might not even want to do anything for your life plan, because God, the Almighty God says, I have a plan for you, and that plan is good. But that is what it means per se. God means that definitely has a purpose for us, he has a plan for us, but we need to receive great wisdom from him to be able to work in his plan. And one of his plans for us is that it shall be well with us here on earth. One of his plans is that even when we are not in existence anymore, we have transited even into heaven, we'll be able to leave a legacy in quote behind. We'll be able to ensure that life for our dependent will also be well, so it's not just for the now, but also for the future to come. So planning in every stage of life is good. In fact, God himself plans for our life, and he expects us to also plan. That is why in Luke chapter 14:20, it says, suppose one wants to build a tower. Won't you first sit down and estimate the cost to see if you have enough money to complete it? So God is expecting us to plan. Nti ade bia mu a yeye bia no, Ewurade hwɛ kwan sɛ yɛn nso yɛbɛyɛ dɛn, yɛbɛ plane, yɛbɛsiesie, yɛde nneɛma ɛbɛyɛ dɛn, ɛbɛtutu yie. And therefore tonight, as we have met, our desire and our aim is to talk about what they call life insurance. And obviously, God is our ultimate insurance, our protector, and is our everything. But there's one thing that we know. The insurance of God for us on life does not include living on life forever. There's going to be a time, appointed time, where we will all transit and go to be with the Lord. And therefore, whilst you're on earth, there's the most importantly, we need to understand and to know that we will plan for our lives as we live here. And then obviously, God takes care of our plan, our life after our existence from here. Indeed, I was reflecting on something and realized that the system is wise sometimes. That's what the Bible sometimes tells us, that we should be shrewd in the way we deal with things. For example, if you don't have a mortgage insurance, there's no way a bank will approve of a mortgage for you, because they know that if anything happens to you, at least with the mortgage insurance, they'll be able to get their money. They'll be able to sort themselves out, whilst you also sort yourself out. Life insurance has become very important for us, and many at times, as people from African descent majority, normally we don't take some of these things very to heart a lot, and we leave it to bear when issues and situations happens, then it becomes a problem. That's why tonight we have gathered, and we are praying that the Lord will help us to gain understanding from our two lovely ladies who will be taking us through what they are prepared for us. But Proverbs 15:22 says something that really touched my heart. It says, plans fail for lack of counsel, but with many advices they succeed. Plans fail for lack of counsel. And the reason why this particular scripture has me, also nipa insusie timi basa inkyerɛkyerɛ enimu a, in other words, futuo enkanwa. Now, because I was talking to somebody, and you know how people can talk from their mind as if they know it all. I saw your investment too. I saw your investment. I saw your investment. They mentioned the big word investment, but then sometimes they don't even understand the details of how to go about investment and anything. Sometimes they saw but they don't understand. So they don't understand. Plans fail for lack of counsel. These plans are in the heart of people. They need to invest. They need to secure their children's future and all that. They are in the heart of people, but without counsel, without a proper channel of advice, it might all not succeed. And that is why tonight we have gathered. Finally, Ecclesiastes 3:11 says, there is time for everything and a season for every activity under the earth. So we should bear in mind that there will be time for birth, time for death, time for anything under the sun. And it's interesting to know, for example, when the royal family, they've given a new royal comes out, or a new prince or princess, whichever, straight away endowment funds are created for them and all that. And most often than not, as believers and Christians, we lack in understanding of some of this. There are times for everything. I pray that tonight, as you have gathered, Odum yenya nimdia afa yekofie ne ani abusua tenase a yebetumi de aye adwuma na yabo yebusua ehu ban honam afam na se wade so bekoso abo ye hu ban obviously hu afam and honam afam as well. And I pray that tonight's session shall be a blessing to all of us in Jesus' name. Amen. 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 Ella also to give us her presentation as well. Thank you.
Thank you. Thank you, Pastor, for the opportunity, Pastor and Auntie Ivy. I'm very grateful. So just before I start, I think Pastor has said a few bits in terms of the importance of having a will. None of us look forward to death. We don't look forward to dying. We don't look forward to losing any loved ones around us. But as has already been said, so long as we're here on earth, death is inevitable. So today I'm going to talk briefly about wills and probate. Pastor said that it's not in depth or it's not detailed. It's just something that should trigger us to decide on what we want to do with, our assets. And I say that because there are a set group of people who are regulated to give advice when it comes to wills and probate. So if during the course of today's presentation, it comes to mind that, you want to look at your assets or you want to go and do a will, I would personally encourage that you go out there and find somebody to help you to manage your assets. So wills and probate. So I'll start off first by explaining what a will is. A will is a document that gives information about your wishes upon your death. So one day, when that day finally comes and you're no longer here, this is a document that puts together all your wishes. A lot of the time we feel like it's limited to maybe our properties and our money. But through the course of the presentation, you will find that there are a lot of things that can be put in a will that we may not have been aware of, but will really benefit us. So it's a document that coordinates and arranges the distribution of somebody's wealth after their death. I've added probate to it as well. And probate is the document that it provides instructions on how your assets are dealt with. So when somebody passes, the person who has been put in charge to take care of that person's assets has to get what they call a grant of probate. And so, for example, if you own a house with somebody and the person dies, it's with the grant of probate that you will use to go and tell them that, this person has died and now you're the sole owner. So probate and wills go together, they go hand in hand. If you have a will, then surely when you die, there'll be probate. If you don't have a will in place, there'll be no probate. So probate and wills go hand in hand. And then lastly, who can make a will? Anyone over the age of 18, anyone who's of legal capacity over the age of 18 can make a will. So those are the basics when it comes to what a will is. It is any document that puts together your wishes. And I want to highlight that because you may have a document in your room and it says, when I die, I want this house to go to A, this house to go to B. And that document is classed as a will. Even though you may not have done it officially with a solicitor, it is still a will. So just so that we're aware, that is any document that puts together your wishes, it coordinates or distributes your assets after your death is a will. Okay, on that note, talking about valid wills, we have a lot of situations where people have passed and family members have come with a will and said, oh, this is the will that my brother left behind. This is the will that my husband left behind. And upon looking at the will, some things are missing. And because of that, the will is deemed invalid. So I just want to go through these points here just to highlight what makes a will valid. So firstly, the person who is writing the will should be over 18. You should be writing the will voluntarily. So not that your daughter knows that you have some assets hidden somewhere and she's pressuring you saying, oh, you know, send these properties to me or put this in my name. If you're being put under pressure to write a will, it would be invalid. If it can be proved that you were under pressure when you were writing the will, it would be invalid. Thirdly, it should be made of by a person of sound mind. So it's important that we do these things as early as possible, at the earliest opportunity. Sometimes as we age, and I think our Deaconess Sarah has spoken a bit about it, you can encounter various illnesses that maybe at a younger age you didn't foresee. Something popular like dementia or Alzheimer's, which means that you're not of complete mental capacity to make decisions. So it's important that a will is made by somebody or person of sound mind. And I would say that if we were to do our wills as early as possible in our lives at the earliest stage, we would make sure that, you know, it would cover that point, that we will be of sound mind. That's to say that if somebody who maybe a millionaire is struggling or having like mental illnesses or is mentally like not capable, that person wouldn't be of sound mind. So anyone who, you know, is making a will should make sure that, you know, it has to be made by a person of sound mind to be valid, it has to be done voluntarily, and you have to be over 18. The next point is that your will has to be in writing. So I mentioned earlier that you could have written your wishes down on a piece of paper, and that's very important. It wouldn't be that maybe you were in a family meeting and you have said that, oh, I want this house to go to my first daughter, I want this house to go to the second, and I want my last two sons to maybe take the money in the account. That is not a valid will in the UK. I'll reiterate that it's possible that it is valid in other countries, in other jurisdictions, but if the assets that we're talking about are in the UK, it has to be in writing. Next is that the person who's making the will have to sign it. So if on the document you have your signature on there, it's a valid will. And you have to do this will, or you have to make this will in the presence of two witnesses. If the two witnesses also have their signature on there, it is a valid will. The thing to note about the two witnesses is that it shouldn't be people who are beneficiaries of the will. So if you have property that you have given to your daughter and your son, you can't use those same people or even people who are connected to them to be witnesses. And this is done so that if in future something should happen, if there's any question on the validity of the will or whether there was pressure being applied, the witnesses will be able to say, the witnesses will be neutral parties to be able to say, oh yes, this will was valid, it was done, two witnesses, we're not connected to any of the people who are beneficiaries. And then lastly, the two witnesses must also sign in the presence of the person who's making the will for the same reasons. I've put date at the bottom and I've put some asterisks next to it. And it's because if you do a will, if you, you know, write a will and you don't put a date on it, it is still a valid will. It is still a valid will. It's just that sometimes it can raise problems when, for example, if maybe you had written that will in the year 2005, and at that point in time, you didn't have all the assets that in 2021 you have. In future, when you're not there, it is very difficult for people to prove that these were your wishes when you became rich, or these were your wishes before you know, attained these assets. So it's very important that if at any point in time, you're documenting your wishes on paper yourself, that you date it. The fact that there's no date on a will not invalidate it. So if we then find a will later on and it has no date on it, it'll be very difficult to prove which are your wishes at which point in time. So that's a key point that I'd like to make there. I said earlier that I'd encourage that you find a professional who's regulated to help you to write your will. But the truth of the matter is you can write it yourself. If you go through the points that I shared on the first slide, making sure that you've covered all of these points. If all of these things are on your will, then it is a valid will. So you can write it yourself. But I would encourage us to seek the advice of a solicitor to write wills, just because it's very easy to make a mistake. And when it comes to these wills, when it comes to that time when you're no longer there, you won't be there to explain the mistake or explain your intentions. But if you've gone for a professional to, maybe take the information and understand your wishes, they will make sure that it is written in a way that is understood by everyone at the time when you need it to be. It's very easy to make some mistakes in wills in terms of maybe where your assets are, if they're scattered across the world and all of those kind of things. I would recommend that we go and get professional help to do this. I think the assumption is that wills are expensive, or that they look at maybe your assets and then decide how much to charge. Generally in the UK, a straightforward will, a singular will cost between £100 and £250 per person. So in comparison to maybe the assets that you're leaving behind, £100 to 250 is not a bad amount to secure your wishes, to make sure that, there's no problems that come or arise after your death. If you're doing a joint will, so I think when Deacon Sarah was speaking, she spoke about SOL and the joint insurance policies. It's a similar concept here as well. So you can have a joint will with your partner or your spouse, and that would be between £250 and £300. If your will is a lot more complicated, so you have a lot more assets, you have businesses, you have shares, things like that, then of course it will be more expensive. But once again, to secure your property or your assets, it would be important for you to spend what I would say is a little bit of money to secure your greater assets. So obviously I've written that, you can write your will yourself and get somebody to witness it. But make sure that the person who is witnessing is not related to anybody who is written in the will. I've also put here that if you have multiple assets or you're not in a straightforward situation, as I've already said, for example, you have other children who maybe your current spouse is not the children of your current spouse. If you have other children who live abroad or live elsewhere, for example, live in Ghana or live in other parts of Europe, it's very, very important that you seek legal advice when writing the will, so that on the event that something does happen to you, the executor of the will make sure they contact all of your children, contact everybody who is involved. We've got some case studies coming up, but you realize that when sometimes you find yourself in situations where people were not aware that there were other people who were beneficiaries to a will, and it can cause so many problems. So it's very important that if you are in something that we wouldn't call a straightforward situation, that you would seek advice to write your will. And then lastly, if you want to update your will, so I made an example earlier that you may have written it in 2005, and now in 2021, by God's grace, you've come into some amazing money, and now you want to secure your assets for your family. There's something that we call a codicil. So it's an addition to an alteration to your will. But I'd advise that so long as you're not making major changes, then you can use a codicil, just something minor that you want to change. Maybe the amount that you had put on there previously, you just want to change the amount and increase it. But if it's, major changes that could be easily misconstrued, the advice is that rather than updating the will with a codicil, you destroy the will that was created and then you make a new one. So again, I'll go through quickly what invalidates a will. So it's signing under the influence or undue pressure. If somebody is forcing you to sign and leave money to them, that invalidates a will. If you're signing without mental capacity, And then if there's any evidence of fraudulent activity. So for example, if you're found to be trying to put in a will, maybe the proceeds of crime, money that you've acquired illegally, not us, but I'm just saying that sometimes we come across those cases, those wills would be invalid because the money in itself is from the proceeds of crime. Sometimes people have assets and they seem to have contradicting wills. So you may have a house and you have a will in the UK, and then you have a house in Ghana, and you've also in the same will in a will in Ghana, you've also shared it to different people. I'll talk about that a bit more in detail, but I just want to say that that is one of the sad cases where you see a will being invalidated because there are two wills that are contradicting each other and we can't work out which will is the later one. So it's very careful. It's very important to make sure that if you have assets across the world, that you have a plan in terms of how you are protecting these assets. So that's what I'll say for now. Very quickly, if you're writing a will, the information that they'll ask you for is who you want to benefit from your will, who should look after your children, if you have any children under 18. So I said earlier that it's not just our money that we can put in wills. So some people say, oh, I don't have any money, so I'm not going to bother with a will. I would encourage all of us, if you have children, that you should get a will in place. They'll ask you for your details of assets, who is going to sort out your estate or carry out your wishes after your death. What happens if the people who you want to benefit from you, if they die before you? And then also, you can include a charity in your will. I want to speak very briefly about the charity aspect, because I know that a lot of us pay tithes or offering to the church. And something that I came across recently, or a few years ago, I should say, is that a lot of the time we hear that when maybe other communities, I wouldn't say white people, but the other communities, you hear that they leave a lot of money to maybe dog charities or you name it. And as maybe Africans, sometimes we laugh and we say, oh, they've left their money to dogs, or they didn't know what they were doing, blah, blah, blah. And something that's really important when you're writing a will is that when you're leaving money in the UK, applies to UK wills, whoever is inheriting that money or the assets, if your assets are above, I think it's £225,000, they are liable to pay inheritance tax. So 225,000, it sounds like a lot, but if you're a homeowner and you leave your child just one house, they will be paying inheritance tax. Now, one of the ways in which you can avoid inheritance tax is to prove that you've been given to charity over the course of your life. And if they see that you've been making consistent donations to charity, they deduct your donations to charity from the inheritance tax that your children or whoever you leave your assets to would pay. So I would just like to bring to our minds that for those of us who are gift aiders, or those of us who pay tithes, pay offerings in church, gift aid your donations, because it's your gift aid that will trigger the system to give you that deduction when it comes to inheritance tax. It covers so many things, but particularly when it comes to giving property over to your children, to your spouse, the inheritance tax that they may have had to pay. And sometimes, depending on how much you're given, it can be up to 25, 30, 40,000 pounds. You receive a significant reduction because of maybe the tithes and the offering that you've paid across time or over time. So this is also why it's very important to seek professional help when you're writing a will, because they can help you, they can point some of these things to you. If you're writing it by yourself, you may not know of all these benefits. And then when you're writing a will, they'll ask you if you have assets abroad, if you have multiple wills. Some countries will require that, the will or the property should be protected with wills from their country. So I think if I'm not wrong, places like India, you have to be quite careful about how you protect your assets. Maybe a will in the UK may not necessarily cover your property elsewhere. So it's important that depending on where your assets are, you check what the laws of that country say concerning your property, because you can put the property in your will in the UK, but it may not have any benefit to you, or it may not have any benefit to your family when you're gone, if they can't prove that it's valid. Okay, intestacy. So intestacy is what happens, or the laws that govern those who do not have wills. So I've spoken quite extensively on what happens, what a will is, how you create it. But for those who do not have wills, which I think maybe at the moment would be the majority of us, I think the common notion in the UK is that, if you have a partner, your partner will inherit your assets. If you have a surviving partner, they'll inherit your assets. But I just like to point out that in the UK, a surviving partner has no claim on the property or rights to the assets of their dead partner. And I will make a differentiation between a partner and a spouse here. So if you're a spouse, you're protected to some extent. But if you're a partner, so you're not legally recognized as married in the UK, you're not legally recognized as married in the UK, then you'd be classified as a partner. There are other areas in which common law partnerships are, what would I say, recognized. But when it comes to wills and property and inheritance, common law partnership is not recognized. So in order for you to have any claim or rights on properties after the death of a loved one, you'd have to have been married to the person. So that's the first thing. Intestacy laws are basically the laws that are in place to govern people's assets when they don't have a will. So if you die and you don't have a will, they'll ask, okay, do they have a husband or a wife who is alive? Is the estate more than 270,000? If the estate is more than 270,000 pounds, then the surviving husband or wife keeps up to 270,000. And what is left? So for example, if they had a house and the house was worth 300,000, the surviving wife would take, or husband would take 270. And the 30,000 that is left is what would then be divided amongst the children, the grandchildren, and whoever else. And even with the 30,000 that is left, the surviving spouse will still get 50% of that. So if 30,000 is left, then they will still take 15,000. And then it's the 15,000 that is left that is divided equally among maybe 4 children, 5 children, which sometimes we think, oh, okay, it's okay. If they're all the same, mom will make sure she takes care of the children, or the money will go to the children anyway. But I think sometimes where the difficulties is that some of these, for example, you may find yourself in a situation where father has remarried. So the wife who has taken the assets isn't necessarily the mother of the young children that the father has left behind. So it's very, very important that rather than leaving some of these things to intestacy laws, we put a will in place to make sure that whatever happens, we have our families covered. Let me put it that way. So every family setup or their circumstance can change the calculation that I've just given. So for example, you may not have a surviving husband or wife. You may not have a brother, you may not have a sister, maybe no grandchildren. It will go to your half brothers or your half brothers' children, and UK law will trace it all the way. But if it gets to a point where they feel that there is nobody who is related, blood relative, or nobody who can prove that they're blood relative to you, then the money goes to the Crown. So we hear sometimes that, this person died and they can't find any relatives and they've taken the assets. That's how it happens. Survivorship law, and this is for people who have bought property in the UK. And I'll just say really quickly that when you buy a property in the UK, there are different ways to buy the property. Especially this goes to a married couple. So you can buy as joint beneficial tenants or tenancy in common. If you buy as joint beneficial tenants, whatever happens, whether there's a will in place or not, if the partner dies, the house automatically goes to the husband or wife who is surviving them. So that is a law that I guess sits above intestacy law. So if you've bought the property, you can check in your title deeds whether it's joint beneficial tenants, then it will, whatever happens, no matter, even if, okay, let me say, if you bought as husband or wife and you've willed the property to your children, even if you die, it will not go to your children because that law sits above the will laws, let me put it that way. So if you've bought as joint beneficial tenants, then whatever happens, when one partner dies, the property will go to the other, sorry, not partner, spouse. In the case where both have passed, then it will go to whoever you have willed it to. But if you've bought as joint beneficial tenants, then survivorship law, it sits higher than intestacy law. There are other ways in which you can buy properties. So tenancy in common, if you've bought in tenancy in common, usually it will apportion shares to each partner. That way you can say that, okay, I bought 60%, you bought 40, I will my 60 to my mum, and your spouse can will theirs. That's fine. That sits under intestacy law. But if you've bought as joint beneficial tenants, then survivorship law means that it would automatically go to the spouse. That's very, very important, as I've said, because you may have been in a previous marriage and you haven't maybe nullified the marriage officially or legally in the UK, and you've written a will and you think that, oh, I've put in the will that the property should go to my first daughter or son. But because survivorship law is above intestacy law, whatever happens, or the wills and probate law, whatever happens, if you pass, then that property goes directly to the person who you were legally married to, even if you've separated, whatever the circumstances, so long as you're still legally married, the property will go to them. So it's important for us to check, Deacon Sarah said earlier, make sure that you know what kind of policies you have, make sure you're aware of how your property is owned, and what laws govern the properties that you have. And then, of course, if you don't have a will, it's very important to make sure that you get something put down. I mentioned earlier about children. If both parents were to pass, we assume that family members would come and take the children. But it's very important that to know that kids could end up in foster care or under local authority care before they determine who legal guardianship goes to. Under some circumstances, under some local authorities, they do allow them to stay with the family, but the actual legal guardianship, so the decisions that the parents would have taken when it comes to legal issues concerning the children, will lie with the court until a guardian is appointed. So it's important that if you have children, you may think that, okay, you don't have any properties or anything to leave them, but what you could do is, or what we advise that is done, or what I'd encourage, is that you specify who your children's legal guardians are in a will, so that, God forbid, anything should happen to both parents, those children would have people that you trust, people that you would, be happy with them, or happy for them to be looked after. Otherwise, the decision then doesn't rest with us. And what goes into making those decisions, could be endless. But I just advise that beyond our financial assets and all of those things, I guess our children would be our most prized possessions. So we would put a will in place and specify who our children's legal guardians would be, should we be called home by God. Assets abroad. I've spoken briefly about this. Assets abroad is a very, very tricky area. So I'll give the disclaimer again. If you have assets in the UK and elsewhere, I'd advise that you, first of all, speak with a solicitor, a wills and probate solicitor in the UK, to get advice on how to protect your assets in the UK, and how your wishes will, be. And then in addition to that, that you would also go and find out from the country in where your assets are. So, the country that the asset is registered. So for example, if you have a 3-bedroom house in Ghana, you'd go to Ghana and find out from there what the requirements are to have a legally valid will. For example, I know that a lot of us maybe have migrated from Italy or France and have now come to the UK. We may have some assets over there, properties, you name it. Right now is the best time for us, those of us in those situations, to put a will together. Because as we know, with Brexit, a lot of laws have changed regarding some of these things. And right now, the UK is still in the Brexit transition period. So when you write a will right now concerning assets in other European countries, they will allow you to, put a clause in there to say which law you want to apply. So maybe the France law, you realize that it doesn't favor your plans. So you want UK law to apply on your assets in France because you live in the UK. This is the time for you to get that will done. Speak with a solicitor and let them help you do that. Once the transition period is over and the new laws are in place, it's very possible that that opportunity will not be there. And then French law will apply to your property. French law particularly, I hear, are very different. They're very difficult when it comes to property and how it's owned outside of France. So I'd encourage us, if we do have assets elsewhere, Italy, Holland, you name it, go and see a solicitor and let them help you to make sure that your will in the UK will cover those things. I'd also say that when you go to a solicitor in the UK, they will encourage you to talk about all your assets across the world. And that's because in the UK, the tax man would want to know, what assets you have. So not just your UK assets. And that's one of the reasons why a lot of people do not declare their assets, to maybe evade tax. I personally would encourage us to maybe do wills in the separate countries that we're in, not necessarily to avoid tax, but to make sure that the countries that we're in accept, the will, and so that if something did happen, it would still be accepted. But just on the point of tax, just so that we are aware, you will be required to let them know all your assets. And that's just UK law. So if you live in the UK and you have assets elsewhere, they're still classed as your assets for tax purposes. I've spoken about getting multiple wills. Multiple wills can cause challenges. So even though I'm advising that multiple wills is a good way, it's important that when you do have multiple wills, you still bring them together to your solicitor in the UK to have a look at, to make sure that you haven't written something in your will in Ghana that cancels something in your UK will, because if that happens, you invalidate your will. And as I said earlier, whichever one is dated the closest to now, or whenever they're reading it, will be the one that is valid. So it's very important to make sure that if you have multiple wills, you seek advice to make sure that you don't face any of those challenges. I'll go through really quickly. Where is a will stored? Your solicitor can keep your will for you. You can store it at your bank. There are companies that offer storage of wills. The London Probate Service is a very popular one. And then, of course, the people who are listed in your will should know where your will is, so that when God calls us home, they'll know where to look for the will and then what to do next. Further advice required. So if you share a property with someone who's not your husband, your wife, maybe even your children, it's important that you look for further advice from solicitors, etc. If you want to leave money or property to a dependent who can't care for themselves, it's important that you seek further advice. If you have several family members who may make a claim on your will, your family members may not be aware, or they may not know the extent to, your family. And it's important that you seek advice and you get all the information put in there. If your permanent residence is outside of the UK, this is very important that you seek further advice when you're writing a will. If you have a property overseas or you have businesses and shares, it's also very important to seek further advice. So I have a case study, I have 3 case studies just to help us to understand a bit of what I've said, and hopefully this will help it sink in a bit. So Mr. Mensah was 58 years old and he died in the UK after a short illness. He's left behind one property in the United Kingdom, one UK high street current account, and 3 savings accounts, including one ISA. And he has a life insurance policy worth 35,000. He also has various assets in Ghana, has a foreign will to cover his properties in Ghana. Mr. Mensah's ex-wife is claiming an interest on his assets upon death, as they have 3 children together and they live in the property owned solely by Mr. Mensah. Mr. Mensah did not have a will in place and he is survived by his new wife of 2 years. They do not have any children together. So this case study is something similar that I guess I should say that they're all based on true stories. The names and obviously the details have been changed. So this man, he had remarried, so he divorced and remarried, but his ex-wife and children were living in the house that he owned. So I guess his children are young, so he's allowed his ex-wife to stay in the house that he owned, and he's moved off with his new wife to another house, and he doesn't have a will in place. And because he's newly married and he doesn't have a will, upon his death, the house automatically goes over to his new wife. So I think I said earlier, £270,000 will go over to the new wife. And then in addition, or whatever's left from 270,000 will be split in half. And then that is what will be shared amongst his children. So the ex-wife is claiming an interest on the assets because they have 3 children together and she lives in the property. But unfortunately, if his new wife asks them to leave, they don't have a legal claim because Mr. Mensah did not have a will in place. If he had a property in Birmingham, for example, and it was worth £310,000, already it's 270,000 is the limit that they'll give to the wife. So she'll get 270,000. That leaves 40,000 from the house. We're assuming that he hasn't put a beneficiary for the life insurance payout. His UK bank balance is £632 and his savings account is 8,983. That gives us a total asset value of £354,615.48. But because 270,000 has already gone to his wife, it leaves 84,615. And as I already said, after they've taken the 270, they then split what's left and then 50% goes again to the surviving wife. So the 84,000 that's left, the new Mrs. Mensah will get £42,370.50. And then the 42,000 that's left is then what will be shared amongst the rest of the children, or the rest of the family, which if you look at is a very sad situation, because for Mr. Mensah to have left them to live in the house, we would assume that he'd be happy for them to stay in the house. That was his intentions. But without a will, this is what the law would do. So it's very important for us to put our assets or protect our assets. The second case study says Mr. and Mrs. Jackson have been married for 12 years and have 4 children under the age of 18. They both died in a ghastly car accident. They own their home and they have a will in place which covers their financial assets, but they did not appoint a legal guardian for their children in the will. And so, as I explained earlier, in this situation, the courts will become the legal representatives until a guardian is appointed, or in some cases, until the children turn 18. And so it's important that whilst we're, putting our financial assets, whilst we're counting our financial assets and putting them in our wills, that if we have children who are under the age of 18 and would need guardians, that we don't forget them or we don't leave them out. And then lastly, the last case study, it says Mary is a single mother of 4 living in Leeds. After battling with cancer for the last year, she died at age 52. Mary lived in a housing association council property. She has 2 adult daughters, 26 and 24, and the other 2 are 16 and 17. Mary felt that she didn't have any assets to leave behind and did not have a will. After her death, the council are attempting to evict her children from the property because the tenancy holder has died. And now the children are in a situation where they have to prove that they have an interest in the property and that it was their intention to live there as their main and principal home and eventually buy the property after their mum recovered from illness. This particular case study, I'll just explain a bit more and then I'll end on this one. When we have people who live in council properties and housing association properties, sometimes because obviously the properties are not owned by us, it's very easy for us to say that, okay, we don't have an interest in the property. But in the UK, tenancies that are granted as secure tenancies or assured tenancies are tenancies that are meant to give us security, lifetime security. And under UK law, if you live in a housing association property, council property with a secure tenancy or assured lifetime tenancy, you're allowed to pass the tenancy on to one person. So it's the law of succession. In this particular case, Mary felt like she didn't have any assets, but she had children who were living in that council property with her or the housing association property. If she had done a will and put in there that she wants her children to take interest in the house, obviously she can't pass the property on because it's not hers, but the interest in the property is what she could have passed. Then the council may have been lenient and allowed the children to stay. It's important to note that when it comes to housing association council properties and all of that, it's not set in stone. It's not 100% that if you put it in there, they'll give it to you. But it is really, really helpful sometimes. So when some of our mothers have been in, for example, council or housing association properties, they've lived in them for as long as, we've been alive. And we think, okay, we're going to move on and maybe we'll find somewhere, buy somewhere and all of those kind of things. It's still important for us to remember that, especially if we have younger siblings and all of those kind of things, that they can still put in their will who they would like to live in the property. And I think it's very important now because a lot of these properties have like the right to buy. So you're able to purchase the property if you want. And if the council are successful in evicting them, first of all, they'd have to go and rent privately, which costs a lot more than council renting. But also they would lose the benefit that was for their mum. And that's the interest that they're passing on. So they can't pass on the house itself, but the interest in the land or the fact that they had that tenancy is an asset under UK law that you can pass. So that last case study is just to point out to us that we may not have anything that we, have acquired or maybe is worth physical cash to us, but just the security of tenure, living in a council house and paying that reduced rent, making sure that your children still have somewhere stable to stay even after you've passed is something that we can also add. So yeah, that's the end of my presentation. Thank you.
Wonderful. Thank you so much. This is quotation, and I just took a photograph of it that Dickon Sarah mentioned. So talking about wills, and this doesn't mean you're going to die, but because you are going to, because of those you love that are going to leave. And I think that's the spirit behind the whole thing, so that we don't become people who, we will live and we are not aware about some of this, and something's happened. As ministers, we come across a lot of issues like this where situations happen sometimes suddenly, and we realize that things have left behind for too long. And so let's interact.
Say the crown, we're talking about we'll go to, maybe I should say, the government or the Queen, or when we talk about the crown, it's technically the Queen, but it just means that it's going to be owned by the United Kingdom or Great Britain. It's going to go into central reserves, maybe to help with the NHS or who knows, but it's just that the money will be lost. Once it's gone into the crown, that's it, it's gone. Probate, what happens is that once that person has passed, you then apply for probate. So there's the London Probate Service, or depending on where you reside, you have to apply for probate, and they will give you this document. They'll ask you to serve a death certificate. They'll ask you for all the information to prove that the person is truly dead, so that you're not trying to claim on somebody's house when maybe they've moved to Ghana, for example. So probate is the document that will then say, okay, this is the person who is certified to maybe distribute the wealth. The person has truly passed, and then it will give, you know, the document. So that grant of probate is what, for example, if you then needed to maybe go and tell the who is it, like maybe the mortgage company or the bank, that this person has died, so now you're the sole owner. It's the grant of probate that you would use to prove that, okay, you're allowed to distribute the wealth of XYZ, that they have truly passed and you're the right person. So without grant of probate, for example, you could have 4 children whose father has passed, and everybody's trying to go to the bank to say that, oh, my dad's passed. But without probate, they won't listen to you, they won't hear you. So the probate itself is given, I mean, you'd go to a lawyer and they would go and they would apply to the London Probate Service and get you that letter once you provide them the death certificate. So probate itself doesn't come until the person has died. You can't get probate in advance because you need the death certificate to be able to get the probate.
Okay.
Once the person has died and you have all the you have the will to prove that you're the person who's listed to be distributing the assets, so you're the executor, and then you've got the death certificate and you have the will, then they'll grant you probate. And once you've got that, that's the document that you would use to go around to do all that you need to do.
If you're living with a wife or husband who is not legally married in UK, am I allowed to claim his or her pension after death? That's somebody's question.
When it comes to things like pension, life insurance, and things like that, you're able to you're able to nominate a beneficiary. So if you have nominated a beneficiary for your life insurance or for your pension in this regard, then it wouldn't matter that you're not legally married to the person. However, if you haven't, if there's no there's no nominee for the pension and the person has been paying into a pension, there's no nominee, and then you don't have a will that says that the pension money should go to you, and you're not married to the person, then you have no claim. So it's very important that if you're not legally married to the person, that you have a will in place to pass the pension over to you, and that they nominate you as the beneficiary to the pension. Otherwise, maybe if the children, blood relatives, will have a claim over you. That's how I should put it.
Can a friend be listed as a guardian, please? From somebody's question for children, yeah.
So I think with legal guardianship, the choice is down to the parents. I don't know exactly what or after, because I said earlier that you can put some of these things in your will, but it's not necessarily the case that that's what will happen. For example, if at that particular time they're not in maybe a good accommodating area to be able to accommodate the children, then other things will be looked at. So you can put them in place, but it doesn't necessarily also mean that that's exactly what will happen. The welfare of the children will always be paramount, but it's just so that there's an indication of what your wishes are, and if possible they would do that. So I do believe you can list your friend as a guardian, but for example, if you prefer that they go to a friend rather than a family member and you don't list it, it's more likely that they'll let them go to a family member because they assume that they'd be safest with family. So
thank you. So like from the research you brought up, it is known that within the Black communities they don't take life insurance at all, because I don't know whether it's a myth. If you take life insurance or you do well, you're going to die, that kind of thing. So they don't do at all and all that. And those who do it as well, as we know, after 3, 4, 5 months, this £20 cry, how much? Then they cancel it. Then they don't know. They've just canceled it. Then nobody kind of know. So I wanted to find out, what advice can you give? And then what do you think will be what you've come across in terms of the barest minimum of minimum? Because something that if somebody's paying, it doesn't really cost them that much, but in future they realize that it was beneficial that they were doing it, if you know what I mean. In your experience as a broker, whichever way, what's the barest minimum? Let's say you can get a cover letter of £5, can give you up to kind of this, up to kind of this, so that somebody, instead of spending, let's say, because we spend £40 a month on phones, £35 internet here and there, and then we ignore life insurance, which might be very important in future for us and maybe our children as well. So what advice?
So what we know is that the price that you pay is definitely based on how much you want to be left, how much you want to leave for your children. I know that there are some companies that do probably £5 a month, or sometimes it starts from £5 a month. But then there's a probability that if you are not, if you have children and you have you are older in age, or you've had like a sickness in the past, it may be more expensive. But how much it costs all depends on, so you don't necessarily need to have like a higher amount. You can have like a small amount to leave behind for your children. And then that's what ensure that you are paying a minimum amount instead of a huge amount. But as you said, sometimes you put our priorities in the different places, like a phone. Some people keep their Netflix and then cancel their life insurance, which depends on you. You have to put priority on making sure, because we have been educated now. So you have to put priority on making sure that your children are protected, or your spouses are protected when you are no longer here.
Thank you.
My question is concerning the life insurance. I think it says most of the life insurance they are among beneficiary forms are waiting me fail it a bus in the one how to share your money across so you know, a part of the will and maybe just say so part of the will insurance no is that allowed so or lawyer big copy and I say you can keep the copy for yourself.
Okay, so with regards to life insurance, the insurance company will know and will have the details of the beneficiaries anyway. So if you so the will part is different. However, when you die, somebody has to inform the life insurance company. So whoever informs the life insurance, so you have to let maybe your closest people know that you have life insurance with X, Y, and Z company. So when they are informed, because you have given them the names of the beneficiaries, they will be able to give these particular beneficiaries the money. So, but I think, I'm not sure what Dick Nisela will say, but I don't know if he can also put it in the will as well.
I think just as you said, so you would put in the will that you have a life insurance policy with XYZ, so that the executor would know to inform them that you've passed. But if you have beneficiaries on your life insurance, the will cannot override that. So the beneficiaries in the life insurance is what would stand. I think where the complications come is if maybe those people that are listed, your nominees, have passed away, that's when maybe it can pass. But otherwise, you just inform them via the will, or your executor will inform them you know, that you've passed. So you just inform your family members via your will that you have a life insurance policy, how much it is and with who, and that's all that's required.
I mean, I think one of the when Ella was talking about, so be to cancel flat for years. As we know, cancel flat, what na cancel flat after 5-6 years, it's almost however, if you sell in the back, there's a lot of money you can get it. In as much as no can or say no, and yeah, but because of what now watch and a but na na sabi nisika kasa uto wankasa umoja nasa uto. So you are able to still do a way to say that I still want my children to have interest in this place. Into sabi that is when they're under 18, right? Or for any age.
For any age. For any age. I think
For
if they're
any
under
age.
18, it's easier. If they're older, usually they just have to be able to prove that they live at the address or that, you know, they frequent the property, but it's for any age.
That's right. So internet also can say it can also be a very good investment for your chimba in a way, because Ubetimato Dan be at 40,000. Meanwhile, it's worth about, let's say, 150,000, 120,000. So Martina Huache, now Unia Japade say what the ample. But then you've done a simple way to say there's a 77 predators already from here, but some any interest in this place. Now wants to me go ahead to say the young shepherd say it means that at least in a way, you know, you have left something behind for the children in quote. And I think that's a highlight for what I've learned tonight. Somebody says, I know someone who canceled his life insurance because it was up to 80 years. And then if you are not diseased by then, you do another one. The person is 60 plus. He therefore stopped it and he's putting money aside in private account. Is it safer? Okay, I don't know how to answer this question. So,
I think that if they're just putting money aside, because for example, if you are paying a premium of maybe £20 a month, and then you cancel it and you put it aside, it's not going to yield any benefits for the family, because £20 a month for 20 years will not yield any, unless maybe that person is trying to invest it into something. So you can also, so usually life insurance, probably you can take it to your retirement age, maybe when you are 60 something. And by then, if your children are away, you can then invest and put them into trust for your children in that way too. That is also advisable. But canceling it versus putting it in a private account, it will not be safe unless the person is investing it.
Concerning the cancel a flat once a bus be a open show interest for your children and as a family member. Or not necessarily lawyer na a process and I say you can go straight to the council to do that process.
And then I'll call direct to the housing association and ask a council for her, and then you let them know, say you want to succeed the property succession. Into usually you don't need to involve any solicitor, but then you can seek the advice of a solicitor to help you to fight the case. But initially you can just go to them directly.
Okay, thank you.
Because in regards to the will, if I and my husband are legally married with the Italian law, and due to document purpose, we are having difference in when one died, what happened to our asset? Oh, so surname. Okay, all right. Dickness Ella.
Okay,
so they are legally married, but they have separate names.
Yeah. If you're legally married, and you have separate names, I mean, even if you're legally married with the same name, usually they would ask you to provide proof of a marriage certificate, because if you have the same names, it could be your brother or anything. So they'd ask you to provide a marriage certificate to prove that, you know, you are legally married, and then that should be enough for that.
Okay, then he's saying that different surname, actually, different surname. Does it really matter?
So no,
maybe
so long as
yeah,
you've opted not to use your marriage name and you're using your maiden name, it shouldn't be a problem. But you'd have to have the proof on the marriage certificate showing that it is you. Or if you've changed your name, then deed poll documentation and all of those kind of things would help you to do that.
Wow. And then somebody said, is it necessarily a requirement to get witness to your will?
Yes, please. Very important. So you need 2 witnesses to witness your will, or to sign that they've witnessed your will. And the 2 people should not be connected or related to the people who are written in the will. So if you don't have that, then it makes the will invalid. And it means that even if you have a will, if it's invalid, then you go back to like somebody who didn't have a will at all. So it's important that you have 2 witnesses to sign, and then that those witnesses are not related to any of the beneficiaries, any of the people who are listed inside the will. Thank you.
Pacho say Obi will life insurance says 70 years and that's 80 years. That's the Babe Swan. That's the still any panel. Nyamia dum table that's what he has. That's Babe Swan. Advice not be many panel.
Sorry, Patrick, last part, Nibio.
Say obi aye life insurance if I 60 and I say 70. Now Bible so the advice not be many panel because as soon
Okay.
as so
So usually, the purpose of life insurance, I would say is to protect your family and then your children. So we are hoping that by the time I will be 70, they're not dependent on you. So because at the age of 70, if you want to take another life insurance, it may be very expensive. So maybe at the age of 70, when your life insurance is about to, then you may possibly take out a funeral plan cover or something. So that one is a little bit cheaper. But life insurance, it doesn't have a cash value at the end. So by the time, unless you take a whole life cover, which would cover you for the rest of your life. But for life insurance, with the 70 year, you can possibly take another one to cover you further. But then because of your age, it will be quite expensive. So the earlier you take it, the better. But then at the age of 70, if your children are grown and they are not dependent on you, then maybe the only thing that you would want to help them with is the funeral cover. So that's like you don't leave them a car at the end of the day as well. So that's what I would advise.
I mean, sometimes people might be 70, but they still have very young children because sometimes maybe birthday didn't happen earlier in life. So he might be 70, but or let's say a 12-year-old, a 13-year-old, and they're still in school and all that. So life insurance as against, let's say, in code funeral insurance, which one might be, can he continue? How would he pay into such?
That person, or maybe it would be advisable for that person to have like a whole life cover then. So the whole life cover, it guarantees a payment at any age that you die. It's just that it's a little bit expensive, but when you compare the benefits that you leave for your children, because the children are very young, then it's possible to get a whole life cover. So that is what will be able to help them. So we always we talk about how life really works in our company. So we try to advise you that as you are we call something the renting wealth. Renting wealth is the life insurance, and then accumulating wealth is the investment. So we are hoping that as you are paying for your life insurance, which is maybe £20 a month, then you're also accumulating wealth by paying into your pension, investing, so that by the age of 17, even if your life insurance ends, then you have like an investment stock for the children that you are leaving. But if you don't have an investment at the age of 70 that you think that it can cover Umbano, then you can take a whole life cover, which guarantees a payment at the end of your life. So that's our advice, either you invest or you take out a whole life insurance.
Where is the place of trust in a will? I don't understand this one. So, Ms. Ella.
Okay, so we have trusts, and then we have wills, and then we have will trusts. And I think the easiest way for me to explain it is that when you have a will, the assets that you're transferring, they transfer when you die. But with a trust, you can transfer the assets whilst you're still alive. So it would be a lot of detail to go into, but there are various benefits depending on, how or what your assets are worth. Maybe tax implications to pass it on. But it's in a sense, you're just passing the responsibility over maybe your assets to your children and whilst you're alive. But if they're under 18, for example, and they can't own it legally at that age, it goes into a trust and it's managed. So long or short, you can have a trust or a will. You can have a will trust. They do the same thing, but it would just depend on the kind of assets that you have, and then the benefits would, you'd have to determine the benefits. So if you want a will trust, I'd say that you speak with a solicitor and they can tell you which would be best for your personal situation.
Thank you. So what happens at age 70 and you don't want a funeral cover? Can the person make claims for the money contributed or invested? So I think, yeah, Sarah.
Okay, so life insurance, the term life insurance works like a car insurance. You are paying to ensure that when you pass away, so when you have a car insurance, it doesn't have a cash value. You cannot go at the end of the year and say that I've paid 100,000, so give it back to me. No. So you are paying to protect yourself in case of any eventuality. So when it gets to 70 and your life insurance, you don't want to continue your life insurance, or your life insurance has ended. And if you don't, that means that the cash, there's no cash value, so it has expired. Do you get it? So it has expired. So you don't get a cash value at the end of your term. So you had 30 years. At the end of term, there's no cash value at the end of the term. But it's just a way to ensure that should you die within that term, your family will get the money that you want them to have. So I will stress it again. It is important that as you are paying your life insurance, you also invest. The last time Pastor brought another to teach us about investment. So you invest so that your children will have, so when you die within that term, they will get the life insurance money. But if God blesses you and you don't die within that term, then you're also not worried because you're also investing. So you're able to leave something also for your children. So that's how it should be in balance. So unless you want to do, again, the whole life cover, because that one is very expensive, but that guarantees a payout when you die.
Okay.
Yeah, I hope that's
I
clear.
think these questions are very eye-opening, so thank you so much again, because again, it's not prescriptive as we are mentioning. I think there's also a stigma in the African context about these funeral plans or funeral covers and all that. And so somebody gets to 70, then his life insurance has ceased, he's not paying again, then he's left it in vacuum, but he's going to live, let's say, to 100. We always pray for long life anyway. So we're going to live over 100 and everything. But it doesn't matter whichever way it comes. Funerals are expensive in this country as it is. I don't know why it's so expensive here. The land you buy and all that and everything. By the time you finish one cycle of funeral, 15,000, 10,000, sometimes it become a big burden on families when they are not prepared. And so I think this advice it's not prescriptive like we mentioned, but just information that's getting out there. Obi ambo modern say obe hwehwemu ne ebeboa onene na ebusua no, and then you try to do. But I'm much particular concerned about say yemu bebre no, we have lived very well in Europe near there, and then obviously we have assets back home near there, and then yambanso your first second generation here almost need interest back home one way or the other. And my concern mainly is how to connect what we have so that in future, because these days I'm selling houses in Ghana and other places also in quote. No, but how do they be able to connect? Let's say, for example, I pass on and then I have something, my children are British born green, they don't know anything in Ghana, but dad has done a will. Where do they start? Do they go to the British High Commission or British Embassy in Ghana, or to say that, look, my dad was a British, blah, blah. How do you do that? Ella, that's the final question maybe, because that's very important to me personally.
I think it really, really depends on the country. So it will depend on the systems that they have in place in Ghana, maybe to be able to check. For example, over here, if a family member dies, you can write to the probate services. They will check and see if probate has been granted to somebody. They'll give you information on their will and all of those kind of things. I'm not sure if we have that kind of extensive service in Ghana, but for a start, you can put in the will that you have something in Ghana that you want them to look at. I would just advise that you wouldn't maybe distribute the wealth in the UK will, you would do that in a Ghanaian will. So just something to tell them that they need to go to Ghana to go and, you know, maybe this particular firm to go. And then when they go there, that firm will also have all the details. That would probably be the best way that I could maybe encourage us to do.
Thank you. Thank you. I think our time is almost gone. On that note, we want to say a very big thank you again to our lovely ladies. It's wonderful. Dickness Ella Asante, God bless you so much for bringing your wealth of knowledge to us. God bless you, lady. Everybody is saying God bless you. Thank you so much. And Dickness Sarah as well.